Imagine this. You spend 2 years building a life with someone on the other side of the world. Thousands of dollars in fees, hundreds of hours of paperwork, and then one letter arrives. Denied. In 2026, roughly 1 in every 4 K-1 Fiance visa applications is being denied by USCIS. That means hundreds of couples every single month. Couples who did everything they thought was right are being separated, some permanently. But here's what almost nobody is telling you. Most of these denials were completely avoidable. In the next few minutes, I'm going to show you exactly why K-1 visas get denied in 2026, and what you can do right now to make sure it doesn't happen to you. Stay until the end, because the #1 mistake I'm going to reveal might shock you. First, what exactly is a K-1 visa? A K-1 is a fiancé visa. It allows a U.S. citizen to bring their foreign fiancé into the United States so they can get married within 90 days of arrival. To get one, the U.S. citizen files what's called an I-129F petition with USCIS. If approved, the case moves to the National Visa Center, then to the U.S. Embassy in the fiancé's home country. There's an interview, and if everything checks out, the visa is issued. Sounds simple, but in 2026, the process has gotten significantly harder. USCIS now uses AI-powered fraud detection systems that automatically flag applications for inconsistencies. Processing times have climbed back to 9 to 11 months at the California Service Center, and denial rates have increased by 15% since 2024 due to enhanced scrutiny. So what is actually causing these denials? Let's go through the top reasons, one by one. Reason number 1, weak relationship evidence. This is the #1 cause of K-1 denials, and it surprises most couples. USCIS needs to believe your relationship is real, not just in your heart, on paper. We've seen cases where couples submitted 20 selfies from the same weekend but couldn't show consistent contact over 6 months. USCIS doesn't count photos. It evaluates whether the totality of evidence demonstrates an ongoing, committed relationship with clear marriage intent. One detailed affidavit from a family member who hosted you both outweighs 50 tourist snapshots. Reason number 2, the in-person meeting requirement. The law requires that you and your fiancé must have physically met at least once within the 2 years before filing the I-129F petition. Video calls do not count. WhatsApp does not count. If you cannot prove an in-person meeting with flight tickets, hotel receipts, and photos with dates and locations, your case is already at serious risk. Reason number 3, income below the poverty guideline. The U.S. citizen petitioner must demonstrate income at or above 100% of the federal poverty guidelines. For a household of 2 in 2026, that threshold is approximately $20,440 annually. If income falls below this, and there is no joint sponsor included in the initial filing, the petition will be denied. Tax returns must be current. Pay stubs must cover the last 6 months. An employer letter on company letterhead is strongly recommended. Reason number 4, inconsistencies at the embassy interview. Consular officers are trained to detect rehearsed answers. If you and your fiancé can't answer basic questions about each other's families, jobs, daily routines, or future plans without hesitation or contradiction, the officer will doubt your relationship regardless of your documentation. Preparation is not optional. It is the difference between approval and separation. Reason number 5, undisclosed prior immigration violations or criminal history. Failing to disclose previous immigration violations, overstays, prior denials, removal orders on the DS-160 form or during the interview is considered misrepresentation or fraud. Under U.S. immigration law, this can result in a permanent bar from entering the United States, and in most cases, there is no appeal. The damage is permanent. So what does a strong K-1 application actually look like in 2026? Build your relationship evidence like a timeline, not a photo album. chat logs over months, video call records, travel receipts, letters from family who know you as a couple. The goal is to tell a consistent, credible story over time. Document every in-person visit thoroughly. Keep your boarding passes, hotel confirmations, entry and exit stamps. Even a short visit can satisfy the requirement if it's properly documented. Know your income numbers before you file. If you're close to the threshold, find a qualified joint sponsor early. Don't wait until you receive a denial. If either of you has any prior immigration history, disclose it, every single time. Proactively explain it. Hiding it doesn't make it go away, it makes everything worse. The 2026 core principle for K-1 applications is this: consistency beats volume. A concise package that tells one coherent story is far stronger than a massive packet full of mismatched facts. If you found this video helpful, and especially if you're currently in the K-1 process, subscribe to this channel right now. Every week we cover the real stories behind U.S. immigration, what works, what fails, and what the government doesn't make easy to understand. If you need hands-on help with immigration document preparation, the link in the description connects you with a team that has handled K-1 fiance cases, green card applications, travel documents, and family petitions for clients across the United States and East Africa. The next video in this series covers the #1 mistake people make after the K-1 is approved, and how it can end the green card application before it starts. You don't want to miss it. Until then, stay informed and stay protected.